welcome everybody to this event about disabled children's social care and how the law should be reformed. Thank you all for joining us. So I'll start by introducing myself. My name is Rosalind Compton. I am the Legal and Practice Development Manager at Coram Children's Legal Centre, and I work as part of the Policy and Practice Change team at Coram Children's Legal Centre, and I coordinated Coram's response to the Law Commission's review of disabled children's social care. A big thanks to Garden Court Chambers for hosting this event, and to Bethan and Ollie for joining us from Garden Court. And as I said, this webinar is brought to you by Garden Court Chambers, by their community care and education law teams, together with Coram Children's Legal Centre, and we're delighted to invite our guest speaker, Dr. Christine Lenehan, as well. So today we will be talking about the Law Commission's recent consultation on restructuring the law on disabled children's social care. This webinar will discuss some of the different perspectives of the potential changes. So, for example, should there be a new distinct legal framework for disabled children's social care separate to Section 17 of the Children Act? When should a child be making their own decisions? Effective means of challenge to social care decisions. Should there be a greater alignment with SEM law? Should there be overarching principles? And if so, what should they be? I will be introducing our speakers in turn as they speak, but I wanted to note for those who had a look at our lineup earlier in the week, unfortunately, Linda Breham, who is our head of policy and practice development at Coram Voice, was among our panel to speak about the advocacy section of the consultation, but she's been called away at short notice, so she won't be able to attend today. All right, so I would like to start by introducing our first speaker, Dame Christine Lenehan, who was the director until recently of the Council for Disabled Children at the National Children's Bureau. Christine began her career as a social worker in 1980. In 2000, Christine joined the Council for Disabled Children as part of the National Children's Bureau. Christine has carried out reviews for both the Department of Health and the Department for Education, and was a lead member of the review of safeguarding children and young people with disabilities and complex health needs in residential settings in partnership with the Child Safeguarding Practice Review Panel. Christine was awarded an OBE for services for disabled children and young people, and in 2013 was made an honorary fellow of the Royal College of Paediatrics and Child Health. In 2016, she was awarded a damehood in recognition of her outstanding work for disabled children and young people, and for those with special educational needs. In 2024, she was appointed as Strategic Advisor on Special Educational Needs and Disabilities to support the government on developing reforms, and she's still working in that area. So, Christine, I'll hand over to you.
Thank you very much, Rosalind. It's a real pleasure to be here. I am a very narrow person, I tell people, because I am completely and utterly passionate about the best outcomes for disabled children and their families. And I spent the first 30 years of my career in practice. And what I kept trying to work out was where in the bit of the system that change happens best. You know, as an individual social worker, I'm a very proud social worker by background, you make a difference you hope you do to the lives of a few children. And then you go up a bit and you think, well, maybe I could do a bit more and maybe I could. And I always believed at some stage there was a plan, somewhere had a plan for making the lives of disabled children better. And I never found that plan. And so I sort of got into the system trying to work out where I could make a difference. And some of the heart of the system and some of the heart about how we make decisions and how we think about the law and the system around it is about where we decide disabled children fit. Whether they are children like other children or whether they are separate from other children. And that's often a balancing act. I started my career, my first attempt at lobbying was as the 1989 Children Act was being written and developed. Remember that this is the first time disabled children had ever been considered as part of mainstream law. Before then, when I was trying to run services, I was trying to run short break services, family support, all that sort of stuff. I was having to use some obscure bit of health law in order to try and run services legally. And I was also banging a lot on the doors of people to try and get them to take the needs of disabled children seriously. And so I come from a place where it seems to me that disabled children should be part of an integral assessment system and delivery system, which does not make them lesser than, makes them as important as, and protects and safeguards them. However, I was really, really pleased to see the Law Commission review, because there's also absolutely no doubt that the law is a mess and needs changing. Sometimes when you're developing law, there are unintended consequences. So if we go back to the 2014 Children and Families Act, which is a very good piece of law, though has some challenges within it, one of the challenges was we were trying to work out with lawyers how we could hold social services to account. What was the legal duty bit of the world? And we came up with the Chronically Sick and Disabled Persons Act, which was still in force then across the whole age group and seemed a reasonable go. Those of us who qualified pre the 1989 Children Act remembered using it. It was the only way you could get a landline telephone for a parent, and the only way you could at that stage get 2 weeks short breaks at Sunny Trees or Sleepy Hollow or whatever we used to send people to. And so bringing it back into something that may provide power felt like a really good idea. Until we got to a point where we realised, and have continued to realise, that nobody knows quite how to use it, what it means, where it fits, and what it does. So trying to work out a simple process for how we support both parents of disabled children to understand their rights and expectations of a system, and professionals who work within it to understand how to make a difference is key. So I've had a long saga with assessment, and I want to start on assessment. If we had a system that worked, we would not have a system where the gateway to baseline services had to be a social work assessment. Why do you need to have a social worker when actually you want your child to join an inclusive brownies pack? When you want to have a day out at the weekend, when you want to access some domestic care and support. And so over the years, we've looked at how you use pre-assessment, peer-to-peer stuff, a whole range of things. Because the only other people who need a social work assessment to access support, primarily, are those whose parenting have been called into doubt. So we go into a really strange dynamic from the outset, with people trying to get an assessment system that fits. And that's where we come up during the challenges. Years ago, there was a big piece of work on what was called the Integrated Children's Services or whatever. It was a reminder of that Little Britain sketch about, the computer says no. So government was building a sort of computer system that would support record keeping and all that for all the right reasons. Except it didn't fit kids who weren't there for a very, we had these wonderful, I think they were called assessments and something sheet. So what they said, for example, was tick all these boxes if 5-year-olds, see if this child's achieving at 5, see if this child's achieving at 11. Obviously, for children who had a different level of achievement, a different way of living, they didn't work. Didn't work. So they kept going back to what does work. And it seems to me what does work, thinking about the Law Commission's review, is a single assessment duty. I have spent hours with lawyers trying to work out, does that mean I'm entitled to an assessment or not? What does it tell us? What does it tell us about what? What does it tell us about a proportionate assessment service? So if I'm coming to you as the local authority, and I know there are many of you in the line, and actually what I really need for my child is 15 minutes because one school bus goes that way and the other school goes, and I need some additional support, or I need somebody just to help me think through the expectation of my child. Why am I having a full social work assessment? Why is the system not flexible enough that allows us to understand what we need? And then it might be that I do need a full social work assessment because actually I'm really struggling. And I'm trying to work out at one extreme, does my child have a place in this family? You know, what are the really difficult decisions I'm thinking through as a parent? So how do we do that? So to me, it is about how we do that. It's also how we understand how to work with parents of disabled children. So, at the risk of offending half the audience, why are parents of disabled children different? They're different because so many of them are the most powerful advocates for their children. That so many of them are researchers, are doctors, are lawyers, are people who actually professionally think through what they're trying to do, often have the intellect, the emotional capacity, and quite often the financial capacity to think through things and then become really clear about what they want. And absolutely rightly. And I am no apologist for it. If my children had had those needs, I would have been exactly the same. But then those very able parents come into a professional system that's often not very able in itself. You know, we've done some work in the past about how long social workers last in the lives of families of disabled children. At one hand of professionals, your consultant paediatrician tends to last the whole of your child's childhood. Your average social worker lasts about 6 months. So when we're working with a profession that's not confident, that doesn't always know how to work with people who are knowledgeable and intelligent and very clear of their rights in the law, and is often quite frightened because their rights in the law often do not equate with the resource available in the locality, we get quite quickly into challenge. And we get quite quickly into a situation where parents feel like they're not being heard and statutory services back away. So if we take one of the sort of common stories of that, you talk about bedrooms. I was a social worker and a senior social worker for many years. I only ever went into a child's bedroom when I needed to. That was often because the parent had asked me to come in to look at how their child was having to live, the resource that was available, the support that was needed, or because the other side of my life, that I was concerned about that child's safety and well-being. But I had to be really clear about why I was doing that. Now, that wasn't the law telling me that. That was me as a professional social worker, used to working in partnership with families of disabled children to look at the best solutions to going forward. So, in terms of assessment, we need to be really clear about what we're doing and why we do it. The Law Commission asks whether there's a separate duty for carers to be assessed. Why? We should be doing a holistic, comprehensive assessment if that's what we're doing, which must, if we look at all the work we've ever done on analysis and assessment, be really clear about a family assessment and therefore what the carers need, and crucially, and one of the things I was really pleased to see in the review, the role of siblings. What does this household need in order to live the life that the rest of us expect, in order to be an ordinary family, whatever that is? But what is it we need? So try and have a think about how we do this. Otherwise, what we do and what we've done is we change assessment into an industry. And at times it is an industry with incredibly limited productivity. So what I watch happen is that families are assessed and then the resource isn't there. Everybody thinks, well, what are we going to do now then? Oh dear, we've got a problem. I know what the problem is. We'll assess again and again and again and again and again. So when I work with an 8-year-old where the family have had 35 assessments, I begin to think, do you know what? There are ways that resource can be better spent. Professional time is expensive, whoever the assessor is. I would far rather we were moving the money into delivering the support and services that families need. One of the things that the Law Commission asks us is about eligibility criteria. I think we've been talking about a national eligibility criteria for about 40 years now, one way and another, in terms of understanding that. We need to be clear what we mean we're talking about and for what. Where are we trying to go? I don't think we'll get a national eligibility criteria. I think what we could have is a much stronger reinforced local offer that has minimum standards attached to it, that is clear about what's possible, that is clear about what delivers. But in terms of eligibility criteria per se, it really is very difficult. One of the things I did at one stage was I was working with a number of local authorities on eligibility criteria. And we took the case files, very careful with confidential information, but basically details of a set of families one social worker was working on, and we gave them to someone else and said, do these people qualify under eligibility criteria? And actually, you can't do it objectively. It's really, really difficult. It's whoever reads the file, it's whoever does the stuff. It's also about the fact that lots of local areas now have eligibility criteria that require a degree in nuclear physics to get through. And that's because we are a gatekeeping service. Fundamentally, there is not enough money in disabled children's social care. And so we invent a gatekeeping service, and that's difficult. And where is it we have to be, and what does that look like? So yes, of course, we should be clear about expectation, and we ought to be clear about how we're deciding things. But a national eligibility criteria, when areas are resourced so differently with so many different pressures, I really can't see it. One of the best moments of my career was during aiming high for disabled children. My background is when I decided to become a social worker and I was going to put the world to rights, being 18, and I got into it. I got interested in the lives of families and how do lives live. And so I deliberately spent the first 8 years of my professional career working residentially, working in hospitals when that's where we put children, so I could understand what happened at night, working on short break units so I could understand what a 24-hour day felt like for family, making my staff work on play schemes when they really didn't want to. So we got a real feel for the lives of families. And I am absolutely clear that one of the best things we do that supports families is we run good short break systems. I hate the word respite. My staff would never say it in front of me, otherwise they'd be out. Because the respite system is about the laying down of a burden. I am absolutely clear that disabled children are not a burden. But I'm also clear that families need support, and that young people need adventure and opportunity, and that's when the system works at its best. At the end of aiming high, we tried to hold the baseline as high as it had got. A lot of money had gone in, and we brought in the short break regulations. Yeah, short break regulations were great to a point where if anybody took any notice of them. As they were then routinely broken, we decided they were important because they were clear and they were absolutely there. And I suppose what it shows you is that you can have a statutory baseline, but that statutory baseline isn't important when somebody takes any notice of it. So try and understand that. I was really, really keen that we go back to a world of short breaks, and that they are short breaks. They are basic stuff that build up. They're not about removing children from families necessarily. They're about providing a range of options which enables families to live the lives that we do. I'm always interested when people start to develop criteria around things like short breaks. So, you know, we talk in the Law Commission review about them being local and accessible. Well, I spent some of my life comparing Newham in East London and North Yorkshire. The reason for this odd comparison was at the time of my working this out, they had about the same school age population, yeah? Same sort of number of disabled children in the system. But obviously Newham was a tight, ethnically diverse, packed London borough. And North Yorkshire, which is stunningly beautiful, as in Newham. I was a social worker in Newham for years. Stunningly beautiful, but it's massive. And what we used to say to people about stuff like that was the delivery models could have been different. You can always have different delivery models. What you're interested in is what the outcomes for children and families are. So understanding how we have a system that's strong enough to hold, but is flexible enough to deliver the services that families need in a way that works for them is really important. I mean, one of the obsessions of the government system at the moment, for all sorts of good reasons, is the cost of travel in the system. Yeah? So the money we spend on send travel, whether that's school to home or home to short breaks, is enormous and out of proportion. And then you talk to people and you say, well, why are we sending this child 50 miles away to do this? I'm not doing that with other children. I'm doing. So what is it we do that builds a system that's based on local, inclusive, supportive? What does it look like and how do we do? I have an interesting support approach to safeguarding, as you probably gathered from the introduction. And I've thought a lot about short breaks and Section 20 and legal requirements and whatever. And I just don't think we've ever got the balance right. So if I'm looking at a family that has an arrangement that works for them, works for them one night a week, one night a month even, 12 days in a year, do I need to have a big Section 20 assessment? Do I need to intervene in that family's lives at that level? How do we get some flexibility, proportionality in something that actually starts to look at how we are supporting families and protecting children? And for me, it's that question we keep coming back to. And we swing between over-regulation and under-regulation, and it's getting that right. The Law Commission looks at charging and direct payments. I have never worked with the local authority charges. I've worked with quite a lot that we're going to, but basically the costs of administering a system which become more expensive than its delivery and the threat of adverse publicity means it rarely develops into anything that's common. What I would be interested in is not charging, it's a waste of time, is actually a new approach to direct payments. We do seem to have lost an approach to direct payments, and I'd be interested in an approach that looks at how we do that, what can we do that, and how that gives families back control to lead the lives that they need to lead without the intervention of statutory services. One of the things that the Law Commission reform ducks is health. I think Ollie is going to talk more about that, so I'm going to lead that to him. But for me, whatever the terms of reference were for the review, it's a huge gap. I've been thinking, right, I've got 2 sections, 5 minutes. The first one is actually about complaints. We spend a huge amount of time and money on complaints instead of getting the system right. My basic response is I don't want anybody else to be part of this system. It's complicated enough all it is. I'm really interested with the role the ombudsman plays. I'm not sure that the tribunal should be involved in social care complaints. I can't see why we need it. I'd far farther with all complaint systems have something that gets solved at the closest level to the child and family. I think to me that's the important thing. And if we're going to bring in different people to do complaints or whatever, we just need to be really confident what baselines we're complaining on. What is it about? Goes back to what are our expectations. One of the things we've never, ever been good at, because we don't really want to be good at it, because it's challenging, is understanding what the offer of the state is to parents of disabled children. I want almost a contract, not quite a contract, far too legal in this audience, but I want a something. Parents of disabled children generally have a child that they didn't expect, a child who doesn't follow the same patterns that other people do. So they need often to have a partnership with the state so that that child gets the best outcomes in life. And as a family, they get the best outcomes. So understanding what that contract looks like, understanding what that arrangement should be is key. And that doesn't mean doing everything somebody wants, but it means about being really clear about what expectations should be. I'm going to end on section 17. Rosalind talked at the beginning about how important it is and where we are. And I have a background which means that I have a view that is not compatible with the one that you're going to hear in a bit. And that's because on one level, I fundamentally believe that any framework that separates disabled children out will always be a lesser one than that safeguards children. And it will therefore be unable to attract the resources and the calibre of staff necessary to deliver it. We don't understand that social work with disabled children is a complex profession. It should be valued as such, and we should have the best of people that work with families of disabled children. We shouldn't have a lesser system which decides that they're not as important. As the lead reviewer on the Hesley Review, I saw firsthand the impact of child abuse, and even now the lack of understanding about abuse and disabled children. 3 weeks ago, the South Yorkshire Police decided not to prosecute against 95 disabled children who had been abused. We denied justice to non-verbal children. We denied justice to the families of non-verbal children. In the past, I used to act as a referee between disabled children's teams and child protection teams. Child protection teams who would get a disabled child in panic. They ring me up and say, well, disabled child referred, what do we do? And I say, you do what you do. You assess, you understand need, you work out what to need next. And disabled children's teams who at their worst got so lost in the tragedy of disability forgot to see the child first. I do understand parental concerns. I can see why it would be easy to take children out of the legal framework and put them in a separate framework designed for them. I can see that. But I think if we paid more notice to the profession of social work in working with families of disabled children, then actually the mad challenges that we see in the system would not be there. And we do have to remember that statistically, disabled children are 3 times more likely to be abused than non-disabled children. My experience currently is that social workers have a very poor understanding of the legal basis for their intervention. They often have a really limited knowledge of impairment. They don't understand how to work in partnership with parents, and they often cling to assessment tools and approaches which are not appropriate. So while I can see the temptation of a new separate frame which is clear and focusing at this stage, I am not persuaded. Implementing these recommendations will require a transformation in how local authorities see their responsibilities for disabled children, and will need cultural change as well as significant resourcing. The other thing is my role currently is to work with government and others on changes in an SEND system. And the crossover between disability and SEND is so strong that I would also not want us to make changes in one side of our system as we start to make changes in the other side. And there I think I will end.
Thank you so much, Christine. So I'll introduce Bethan next. Bethan Harris is a barrister at Garden Court Chambers and a co-convener of Garden Court Chambers Community Care Team. She practices in community care law, in social housing, court of protection, and related public law. She's an editor of the Community Care Law Reports and a member of the panel of counsel to the Equality and Human Rights Commission. She was shortlisted for Legal 500 Barrister of the Year Awards in 2023 and 2024, and she speaks regularly on Welsh language media on human rights law issues. So Bethan, I'll pass it over to you.
Thank you very much, Rosalind. So I'm going to speak to some slides, which Anusha's kindly helping me with. Thank you very much, Anusha. Okay, so thank you. So we go to the first slide. So this is what I'm going to cover: the scope of the consultation, some of the themes in the consultation paper, the current law, i.e. core provisions, our response as the community care and education team at Garden Court to the core proposal, which Christine referred to towards the end of her talk, of a new statutory framework taking disabled children out of Section 17, and then our responses to some of the other proposals. Okay, so we go to the first slide, please. Thank you. Okay, so with regards to the scope of the consultation, just a few comments on that to outline the scope of it. It's focused on services in the context of family-based care. So it's not looking at residential care, family-based care, defined broadly to include kinship care and foster care. It's not dealing with deprivation of liberty. It's not dealing with secure accommodation. It relates to the legal framework in England only. As we know, social care is devolved in Wales, and it has its own scheme under the Social Services and Wellbeing Wales Act, and also has already introduced eligibility criteria. It doesn't make proposals also in relation to special educational needs. I've highlighted what I thought was quite a useful comment, because it certainly fits with my observation, which the consultation paper makes, which is that there is some confusion among many about the distinction between disabled children's social care and local authority support for special educational needs. And that's another indication of how the law has become too complicated. And of course, that is one of the main reasons why the Law Commission has embarked on this consultation process. It's with a view to making the law simpler and more accessible. And then finally, the terms of reference include, and this is obviously a core part of this process, the question whether disabled children should be taken out of Section 17 of the Children Act, so they would not be a section of children in need, and their needs addressed in a separate statutory duty, and indeed the proposal is an actual separate piece of legislation. So go to the next slide, please. Thank you. So some of the themes that are covered quite amply in the consultation document are, first of all, the current law being a patchwork of duties and the complexity of it. There's a whole array of different pieces of legislation. I won't name them all. I'm sure those attending know them well and have had to sort of look at them and find them and piece them together, and it's just all too complicated. Outdated definitions, for example, Chronically Sick and Disabled Persons Act, that's one obvious example. The definition of disability within the Children Act as well, again, uses very outdated terminology. The lack of alignment of the current legal framework with adult social care, that again is of note. It may be thought by those of us who deal with adult social care and with the Care Act that there is a lot more structure and clarity in that legal framework, and why would children's social care not have a similar kind of structured framework? Then the tendency for different teams within social services to operate within silos, and that's an area that Ollie, I know, is going to cover. Too much focus on safeguarding. This is a theme which is covered in the consultation document, and it is something that I've observed in my practice. And, you know, obviously it's not possible as an individual to say how generalized a tendency is. And one only has a kind of anecdotal perspective on things. But what's identified in the paper, and it certainly chimed with me, was a tendency to use the social work assessment as an opportunity to judge parenting capacity through a child protection lens, rather than through a lens of social care need. And it's stated that this has long been a complaint of families of disabled children. And this really is one of the issues that really goes to this question of whether disabled children and the needs to meet the needs of disabled children, whether that objective is going to be able to be successfully addressed with disabled children's needs as disabled children being part of what is otherwise a framework which is geared towards safeguarding. And that really is at the heart of what the Law Commission is dealing with. And then another theme is the lack of any statutory footing for what's called early help, which, as I'm sure many of those attending today will have experienced offers of early help or will have dealt with it professionally, a sort of tier of assessment and of services which is outside the actual statutory framework. And this can lead to some confusion. And also there are reports of it being a kind of gatekeeping essentially, and a steering away from what might otherwise be a more solid service delivery towards something that's more akin to signposting. Next slide, please. Thank you very much. Lovely, thank you. Okay, so I'm just going to look very briefly at the two current core provisions in the law on disabled children's social care as it is currently, because that will highlight what the proposal, the core proposal from the Law Commission is. So the first of the two core provisions that we have now is Section 17 of the Children Act, and you'll see in Section 17(1) what it is a general duty of local authorities to safeguard and promote the welfare of children within their area who are in need, and to promote the upbringing of such children with their families by providing a range and level of services appropriate to those children's needs. So that's the main general duty, and it's owed to children in need, and children in need as currently defined includes a child who is disabled as one of the categories of children in need. And the section provides for a wide range of types of and configurations of services that can be provided for the child and for the family of the child in need, if provided, for promoting the interests and the welfare of the child. And this can include accommodation for the child and the child's family, and assistance in kind or in cash. So it's very broad. And the second of the two core provisions is the Chronically Sick and Disabled Persons Act 1970, Section 2. And this applies where a child is ordinarily resident in the area of the local authority, and where the local authority decides that an arrangement for services is necessary in order to meet the disabled child's needs, then it must provide those services. So what we have here, first of all, is we have Section 2.4 and then Section 2.6, which provides for a range of types of services, which is very broad, which includes certain types of what would be classified as a short break. So enabling the parents to have some support via the support that's provided for the disabled child. There is the second bullet point is that there is no accompanying generally applicable eligibility criteria. So we've heard Christine speak about eligibility criteria, something that you noted, Christine, we've been talking about, you said, for 40 years. So no eligibility criteria nationally currently applicable to this provision. Local authorities can have their own eligibility criteria. Some of them do, others don't. There are often criticisms of that eligibility criteria as not being coherent, or as being irrational, as employing blanket rules such as the Autism Plus requirement. All sorts of problems with some local authorities' eligibility criteria. And then once the local authorities decided that the need should be met, a duty actually crystallizes. So what we have then currently is a sort of hybrid in terms of a duty, because the local authority decides its own eligibility criteria or doesn't have one. So it decides when it thinks the need should crystallize as one that should be met. But when it has made that decision, then it must meet that need. So those are the two core provisions currently. So if we could just go to the next slide. Thank you very much. Okay, so I'm now going to the core proposal provisional proposal that the Law Commission makes, which is for a unified and simplified legal framework for assessing and meeting social care needs of disabled children. Disabled children will not be a category of children in need within Section 17 of the Children Act. There will be national eligibility criteria. This is the proposal, and of course I hear Christine in her doubt that this is something that can in fact come about. But this is the provisional proposal of the Law Commission, that there should be national eligibility criteria in the same way as we have in relation to the Care Act. And then there would be a statutory duty to meet eligible needs. And there will be, in due course, then there would be secondary legislation co-produced by the local authority and central government as to what that eligibility criteria would be. And obviously that will be very key to what is the scope of the statutory duty. So in our response from the Garden Court teams here, we agreed with that proposal. We agreed very much with the idea of national eligibility criteria. We see that work in adult social care. That would avoid a postcode lottery with regards to what you can get. There would be, of course, an enforceable legal duty to meet those eligible needs. It would provide, we feel, a more accessible legal framework, a simpler legal framework, and it would mean less risk of an unwarranted safeguarding type approach being applied, where the job in hand is to meet disabled children's needs. Okay, so just a few more comments about this new unified legal framework, and I've got my eye on the time. So some of the risks, and this is echoing some of the points that Christine has made. There is a risk, of course, if you take disabled children out of the framework of Section 17, which also deals with services for families where there are all sorts of other concerns. And if you're addressing disabled children's needs as their disability-related needs, separate to anything else, there is a risk that some children might fall between two frameworks, or their needs won't be considered holistically. That needs to be something that's very much flagged up, possibly can be addressed by combined assessments where appropriate and dealt with appropriately in statutory guidance. So that will be a risk. It should not mean a reduction in the range of services that are available. This is something that we're very keen to point out in our response to the Law Commission. The wide range of services that can be made available currently under Section 17 of the Children Act, in particular, the safety net of accommodation for families with their children outside the usual Housing Act and homelessness legislation. None of that must be any less accessible than it is now, and that's perfectly possible with the kind of law reform that's intended. And also a power to provide services where eligibility criteria are not satisfied. And as far as the eligibility criteria are concerned, and I think I'm very much at one with Christine in saying this, and this comes out of the regulations relating to short breaks, the Breaks for Carers of Disabled Children regulations 2011, is the criteria which looks sort of broadly and realistically at how you meet a disabled child's needs. And you meet a disabled child's needs by helping the family live a normal family life. That's absolutely central. And that's actually in those regulations. And that needs to be in the eligibility criteria. And I've written that out there. The child, parents, carers must be able to have time to meet the needs of other children in the family, carry out day-to-day tasks which they must perform in order to run their household, and have a reasonable opportunity to undertake education or training or regular leisure activity. Just to be able to have a normal life, they need to be supported in that endeavour. Okay, so I'm just going to go on for a couple more minutes. I'm going to go through the rest of the slides quite quickly. So the next slide. So the rest of the talk is some comments on some of the other proposals that are in the Law Commission's paper. The proposals on assessments, the consultation document refers to the confusion around early help. I've mentioned that. It comments that the current legislative framework is minimalistic. Indeed, it is. Compare the Care Act, which is good structure and very helpful. And the point about that assessment can be through the lens of child protection, and greater expertise is required. We agreed with that and agreed that there should be a legal framework for assessments modelled on the Care Act, and that assessors should have appropriate expertise and training. As far as the proposal on the definition of disability is concerned, it's proposed that the definition should be the one in the Equality Act, and with the proviso that the current exclusions which there are in the Equality Act with regards to a list of impairments, which are addiction, a tendency to set fires, a tendency to steal, a tendency to physical or sexual abuse of other persons, exhibitionism and voyeurism. These are things that are excluded from the definition under the Equality Act, that they should not be excluded, and they are not in fact currently excluded, as pointed out in the Law Commission's paper, from the definition of disability in respect of children currently, and that should remain the case. Next slide, please. So with regards to overarching principles, considerations for decision making that decision makers must take into account, and what's referred to as a final check, the proposals include overarching principles, an overarching principle, which is that the best interests of the child will be the primary consideration for decision makers. Then there is a list of 9 considerations which decision makers must take into account, and then a final check, which must be whether the services that are proposed are the right ones from the point of view of whether the objective can effectively be achieved in a way which is less restrictive of the child's rights and freedoms. So it's got that least restrictive option principle, which comes in as a final check. And if we just go to the next slide, I've set out the 9 principles, and I won't read them out, but they are, as you would expect, they are inspired by the UN Convention on the Rights of the Child and the UN Convention on the Rights of Persons with Disabilities, and other principles that we know well from children's welfare legislation. And our view was that they are very good and very useful, and drawing on our experience of the CARE Act, we felt that it's definitely right to have these principles, and they will assist in starting the whole process on the right footing, and enabling there to be a process which is engaged in more tailored support. And that's a positive that we've seen that's come out of the wellbeing principle in the CARE Act. So I think I am actually going to finish there. I've got a couple more slides, but I'll leave it there because I don't want Ollie to be cut short in any way. So thank you very much. That's everything from me.
Thank you, Bethan. I appreciate you keeping to time. I'm afraid, everybody, we've bitten off quite a tall order by trying to get through, as those of you who have looked at it, a very extensive review by the Law Commission in quite a short period of time. So I'm going to move straight on to introducing Ollie. Ollie Persey is another barrister at Garden Court Chambers. Ollie has a broad public law practice focusing on the rights of children, asylum seekers, migrants and disabled people. He is ranked in Chambers and Partners and Legal 500 across his core practice areas. And his community care practice spans age assessments, asylum support, welfare benefits, and health and social care. He is a member of the Equality and Human Rights Commission's panel of preferred counsel and won a Legal Aid Lawyer of the Year award in 2024. Ollie writes and teaches alongside his practice. He's the consultant editor of Halsbury's Laws on Judicial Review and a visiting lecturer at Oxford University. He co-convenes Garden Court's education law and community care teams. So Ollie, over to you.
Thank you very much. So I'm going to talk about 4 systems issues that are addressed in the consultation. We've put a detailed consultation response together from Garden Court Chambers. It's on our website. It'll be shared with you in the email after this. I'm not going to go into the legal position in any detail. Without wanting to oversimplify, it's more of a vibes for each area that I'm addressing now. So next slide, please. So I did mean it what I said in that I would keep these slides text light. So the first point I want to address is siloed working and how that causes problems with disabled children's social care. And on the screen is a photo of 3 silos representing SEND, health and social care. And as Dame Christine mentioned, the focus of this consultation is not on healthcare in particular. There are some questions that touch on it a little, in particular 52 and 59. There is an opportunity to address healthcare, but it is not a core part of this consultation, which is a missed opportunity. However, if anyone that is a SEND practitioner or a social care practitioner knows, bad decision-making flows from local authorities having separate departments that address SEND and social care. And with what's meant to be the integrated approach following the 2014 Children and Families Act, unfortunately, that hasn't happened to this extent that maybe was envisaged with the creation of education, health and care plans. Section 22 of the Children and Families Act envisaged a holistic approach to disabled children. Section 22 of the Children and Families Act refers to a local authority exercising its functions with a view to securing that it identifies all the children and young people in its area who have or may have special educational needs, and all the children and young people in its area who have a disability. But that's a view to using all of its functions in a holistic way to identify SEND. So this joined up approach was built into the 2014 Act, but has in effect become a redundant or unimplemented provision. In terms of alignment between social care and SEND, which might be one way of addressing this siloed working potentially, our consultation response was broadly supportive, but with concerns about how this would be implemented in practice. So an education, health and care needs assessment is on one level a perfect opportunity to gather all of that information in relation to health, in relation to social care and SEND together by a local authority. If you're having an assessment for one reason, maybe you should address all of the needs in one go. Is that over-assessment of a child? Potentially, potentially not. But one thing I see in my practice, and it links back to the siloed working, is you can have a Section 17 assessment and you've identified a disabled child who's in education and very likely, because of the nature of their disability, would require additional support in their education, but there's no joined up automatic trigger of a section of an EHC needs assessment, that there's separate gatekeeping and a complex application form for someone to undertake an education healthcare needs assessment, to get an education healthcare needs assessment. And that disparity between the two is inconsistent with the statutory scheme that exists in the Children and Families Act and inconsistent with good practice. So siloed working remains a really key problem in decision-making in relation to education health, in relation to education, health and care. The Law Commission missed an opportunity in integrating health fully into this consultation. It does mention it, as I said, in relation to 52 and 59 in particular. There's also a separate mention of mental health provision in the consultation. But given that there's this view that actually a disabled child has holistic needs, the opportunity to align has not perhaps been explored as much as it could be in the consultation. Next slide, please. So again, in the hope of keeping your attention at gone 6 p.m, I have included a GIF. So one of the questions in this consultation is in respect of transition planning between children's social care provision and adult social care provision. And our view is there is a systemic issue with the lack of proactivity in anticipating this transition period. Now, one of the proposals from the Law Commission is a sort of, should there be a statutory age for transition planning to start, and age 16? And on one level, that is a good idea, because it means that actually with a resource-stretched local authority, children's social care team, adult social care team, the necessary collaboration that would be required, not to mention the collaboration that is required between those teams and the SEND team in relation to the EHCP review, having a marker so that people work early and proactively to anticipate actually from 16 onwards there's going to be changes of placements potentially for the in terms of educational provision. How is that going to link in with the transition and planning process? All of that needs to be done ahead of time, so it's not a rush at the end trying to work out, okay, let's get some provision in place when they go off the books of the children's social care team onto the books of the adult social care team. That is a major systemic issue within local authorities, which links in with the siloing that I mentioned earlier. So broadly, having a duty in relation to early transition planning and making sure it's a thorough and full, but obviously a case-sensitive transition plan. Not everyone will need a transition plan as early as 16, but some will. So making sure that there's that degree of flexibility, but also making sure that it's considered well ahead of time is important. Next slide, please. And keeping in the theme of trying to explain the key systemic issues through the medium of this time food. There is a photograph of a bowl of spaghetti bolognese. I've just come back from interrailing in Bologna, so that was also on my mind, to represent the complexity of the interlocking and overlapping legal frameworks between social care, health, and SEND. And this is, again, an opportunity to there's a key opportunity here to simplify, and Bethan's already gone into detail about the opportunity to sort of set out a clear eligibility criteria and the position that Garden Court took in respect of that. But looking at the question of alignment with SEND and the actual interlocking of statutory schemes. So, for example, in relation to the enforcement duty in respect of social care versus health and special educational provision, if you look at an education healthcare plan, the enforcement duty is section 42. In relation to SEND, it's subsection 2. In relation to healthcare, it's subsection 3. That's a really clear duty. It's an absolute duty. It's non-delegable. It's been explored in the case law in respect of healthcare only recently in a case called A against North Central London ICB. But there is clear case law about the enforcement scheme, the time that a mandatory order would be required for enforcement of any provision that's not in place in special educational provision in section F of an education healthcare plan. Really clear duties. There's a strong argument that there's an equivalently strong duty from reading section 2 of the Chronically Sick and Disabled Persons Act, but it's not the same level of clarity that you get from section 42 of the Children and Families Act. And in terms of enforcement and enforceability, or more generally of these provisions, and ensuring access to provision on the ground, and as an advocate, but if you're a parent or if you're legally represented, having that legal clarity is really important. But it's a sort of this oddity in the statutory scheme that section 42 does not extend to social care, given it can be specific, quantified and clear. For example, level of direct payments for social care might be specified in section H of an EHCP, but it's not enforceable in the same way under section 42 duty. That is an anomaly and creates legal confusion and uncertainty, which ultimately is going to lead to a lack of enforceability of those obligations. So despite being interlocked, despite being this integrated approach, there's different legal duties that apply, which creates confusion and uncertainty. Next slide, please. So the other big system issue that I want to speak to before hopefully moving on to questions and leaving enough time for people to ask questions is in respect of the proposal or the sort of suggestion about involving the Special Educational Needs Tribunal. Now, for practitioners that are unfamiliar with the SEND Tribunal, and I'm sure that's relatively few of you on this call, but I will just go through it in a little detail so to bring people up to speed. The SEND Tribunal is a specialist first-tier tribunal that deals with special educational needs matters primarily. Its jurisdiction was expanded through a national trial and what's now called extended powers to deal with health and social care, but can only make recommendations. It can't make binding orders in respect of health and social care in the same way it can in relation to, for example, the contents of section F of an EHCP, the special educational provision. And if there isn't a SEND issue in the appeal, the tribunal does not have jurisdiction. It is in some ways always contingent on having that SEND issue front and centre of an appeal, what are commonly known as BFI appeals or BF appeals, B being need, F being provision, I being placement. You bolt on the extended powers appeals, and it often a little bit of an afterthought. And the focus is on the SEND provision. Now, the SEND tribunal is in many ways good. It's an expert panel. There's a judge, there's two specialist panel members. But one of the big problems and a key accountability deficit with the SEND tribunal, and why caution is needed in terms of a systemic change that brings social care more squarely into the jurisdiction of the SEND tribunal, is resource considerations and the delays that already exist in the SEND tribunal. Now, we address this in our consultation response, but we have very significant concerns about actually the efficacy of the SEND tribunal as a remedy at the moment. You can see on the screen that there are 3 lines there: disposals, open caseload, and receipts. All of those are going up, but notably, the open caseload is going up fastest because there is a growing demand and growing number of EHCP appeals being lodged. In practice, that's meaning you're not getting a hearing in the first-tier tribunal for a year, unless you are one of the lucky few that gets expedition. And there's relatively tight criteria for getting expedition. That causes real problems in a statutory scheme that envisages annual reviews, and you have a right of appeal contingent upon the outcome of an annual review. If it takes you another year to get into the tribunal, where is the accountability in relation to the decision making for that annual review? A year is a long time in the education of a disabled child. If any proposal is going to be implemented to bring social care more squarely into the first-tier tribunal SEND, then the capacity issues in the tribunal need to be addressed and resourcing needs to be substantially increased. But that's only part of the answer and part of dealing with it. The tribunal expertise might have to shift. It's very much focused on SEND to specialist panel members. There's a legal aid and inequality of arms issue in the tribunal. The rates for legal help work are unsustainable, and very few providers can take on those cases. Not to mention the problems in terms of actually qualifying for legal aid as a family of disabled children. All of that creates serious concerns about actually, do you want this tribunal to be having a greater say in social care when on the face of it, it's broken in relation to SEND matters. Now, it doesn't mean that's not a better option than judicial review, and we all know the constraints of judicial review, but it's not exactly a perfect model to be adopted uncritically. So, conscious of the time, I've done a whistle-stop tour of some of the key issues in terms of systemic problems that were raised in the consultation, and particularly the overlap with SEND. I hope that's been in some way helpful. Thank you very much.
Thank you so much, Ollie. So I'm going to jump in the questions because it relates to what Ollie was saying right at the end. So I'm afraid we're going to bounce straight back to you, Ollie. So we're keen to know if judicial review can be used to challenge local authority decision-making regarding social care provision not being included in the HCP and the realistic possibility of parents using this area of law.
So judicial review is a remedy of last resort, and sometimes there are complaints procedures and internal review procedures within a local authority that need to be exhausted first before going to judicial review. If there's not a remedy, an effective remedy that's alternative to judicial review, you can use judicial review to challenge. The problem is social care is an area that's very hard to bring successful judicial reviews in. You'll see relatively few reported cases in this area, partly because there is deference from the High Court in relation to the expertise of social workers, quite properly, one might say, in in terms of assessments. And so establishing irrationality, for example, in relation to social care decision making is really rather difficult. That doesn't mean it's not at all, and can't be used in appropriate cases where the facts are amenable to judicial review, but you really do need specialist advice about whether it's appropriate to bring a claim for judicial review in relation to a specific social care decision. For example, cuts to direct payments might be an example, or a termination of a package might be another example. Like more obvious hard edge rather than qualitative decisions are the more straightforward things to challenge, rather than wanting a sort of substitutionary decision. You don't get that in judicial review. What you do get in judicial review is heightened scrutiny, and the Supreme Court has been clear that because of the profundity of impact of decisions in respect of disabled children and young people, community care related decisions, the courts will it's a more intensive review than you would normally get in other areas of law. So it's not the sort of classic Wensbury formulation that applies, it's a sort of turbocharged version. But it's hard. You need specialist advice. You need to get a good solicitor early.
Thanks, Ollie. Right at the beginning, Katrina Moore from the Independent Provider of Special Education Advice mentioned that the Care Act sets out eligibility criteria for adult social care, and why should this not work for children too? And the availability of resources is surely a separate issue. Later on, somebody in the Q&A said that was asking how to measure quality and statutory obligation without mentioning the availability of resources. And I think it seems like this is a real sort of knotty question about whether the availability of resources should be a separate issue to statutory obligation, or whether it's a false exercise to pretend you can look at one without the other. I was going to invite Christine if you wanted to jump in on that.
Yeah, Katrina's question is an interesting one and makes sense. And when the Children and Families Act came in, and we were trying to do the read across to the Care Act and the Children Act 1989, and none of it made sense, we sort of pulled it apart to have a look at it in that, and we looked at whether fair access to care would be a way forward. You know, was that a model to go forward on? And I'd be really, really interested to hear from Bethan in terms of community care law, whether that's made any difference, because the evidence at the moment is that it's not reduced variability. And so there is some stuff that says, do we go on that model? Are we clear about it or not? So it is an active conversation under discussion if it's going to work and if it isn't. And it partly depends on how we define the children in it. So I think that's been sort of useful. And I've forgotten the second part. I'm sorry, Rosalind.
It was more about it was simply about
Oh, it's about resources. That's why I forgot it.
Availability of resources, how we can
I think it's really difficult because I suppose on one hand I watch both sides. I watch parents make completely reasonable demands on the system for support to their children, and I chair boards where local authorities just don't have the money to do it. And in the end, it becomes almost a political question rather than a legal question in terms of, are we going to resource? What would seem wrong to me out of a Law Commission review and a DFE response is something that then sets a baseline that's not deliverable. And that's the key for me. How are we prepared to support families of disabled children? What is the resource we're prepared to put in? And that's one of the reasons I don't think we'll get national eligibility criteria, because I honestly don't believe people will resource at the level that's needed.
Thanks, Christine. Just going to put Bethan on the spot with a question saying, does Garden Court have a definite position on whether removing children from Section 17 would be a good or a bad idea? Or is it all about how that would be implemented?
Well, I mean, you know, it is about how it would be implemented, but we did come down in favour of that proposal because we, on thinking through how else you could do it, what needed to be done in order to have a really good scheme with advocacy, with proper principles about participation of children, with principles, with the overriding principle, with the considerations that need to be taken into account, and all these things. It's very difficult to do that in a way that is satisfactory if you try to somehow inject it into what we've got. And that, that's what you'd have to do if you wanted to keep provision for disabled children within the wider scheme. So that's where we were with it, that we agreed with the proposal that disabled children would come out of Section 17, and there would be a separate legal framework for children in respect of disabilities. I mean, obviously, that doesn't mean to say that children some of those children may have other needs as well. And obviously, that's something that needs to be treated with care in the way the system works overall. But yes, is the answer to that.
Bethan. And a sort of a common theme coming through the questions is how difficult it is to look at one part of this system in isolation, and as Ollie was talking about, how difficult it is to look at sort of one leg of this, to look at just this part of it without also considering SEND legislation, without also considering health. I wonder, Christine, if you wanted to have another opportunity to come back to add to what Ollie and Bethan have been talking about on that note.
I really liked Ollie's silo slides. I could get that. I got slightly lost at spaghetti bolognese, I have to confess. But I really like the slides because that's absolutely right. And it's that integrated system that we are missing. And I think it's interesting. Government is now looking at major reform in SEND legislation, but is struggling to do it because it's like biting an elephant. It is such a complex system. How do you decide to do it and whatever? So we're already having to look at something that's really clear, that SEND is not the provision of the DFE. It impacts on all parts of government life. If you think about the work on justice and voice that Coram do really well, then what is the Ministry of Justice position on this? Why do 80% of children in youth offending institutions have learning difficulties linked to speech, language and communication? It's that sort of massive systemic stuff. And I think that's part of the challenge. And, if you work with parents a lot, which I have the pleasure of doing, they don't give a monkeys who provides what bit of the system, provides somehow or other it comes together. And yet when you stand back legally and look at it, you stand back systemically and look at it, it's enormous. So when we're moving forward on reform, whether it's the Law Commission reform or the SEND reform, you're always, and it's why these sessions are so helpful, testing on what's the perverse incentive we're now building in? What's the different layer we're now building in? What is the gap that we're in building in the system? And that's why it makes it complex. But I would say just because it's complex doesn't mean that we shouldn't be doing it.
Thanks, Christine. I'm going to go to a very purely legal question now, just because I think it's one that a lot of people might be interested in the answer to. So Shell Hughes has asked, is judicial review suitable for group action? Local authority criteria that only children qualifying for CWD qualify for direct payments or short breaks. Individual complaints have been submitted, and then each child might then get social care provision, but the local authority continue to do this on an individual basis. So I guess the question is whether it would be more powerful or more effective for people to band together and challenge this as a group. Ollie or Bethan, would you like to take this?
I can have a crack at it, and Bethan can tell me I'm wrong. Yes, broadly, it can be helpful to show the court that there is a wider systemic issue. And the primary reason for that is if it becomes academic in your individual case. For example, the local authority fixes the problem for you, or it's no longer a problem when you've got to trial, that is relevant to the court's discretion to hear an exceptional case. So it's very common that because there's an access to justice deficit and public authorities are aware they are operating on a lawful system, they will effectively try and buy off the individual to get rid of the challenge. And you see that all the time, and the broken system remains. So you see that in a whole range of areas, such as the no recourse to public funds system, Send is no different. If you're fortunate enough to get in front of a lawyer, very often the problem will fix itself because the local authority or public authority, other public authority that might be, knows that they're banged to rights and they don't want the court to scrutinise the lawfulness of the wider system. So having lots of cases means it's less likely that all of them get bought off and the system goes unscrutinised. But ultimately, it's a possibility that all of those individual cases, however, if it's not like judicial reviews aren't class actions in the way that you might see in American TV dramas. A multi-party judicial review is generally 3 or 4 claimants, not thousands. So it's still possible to buy off all of those by fixing the individual problem and then rendering it academic for that individual client. And then the system doesn't really properly get scrutinised unless you can persuade the court to exercise its discretion to consider an academic claim, which is what happened. What the leading case on academic claims at the moment is a Court of Appeal case in relation to Send, LM&P against Devon County Council, which was about the timescales for and following annual reviews and a rule of statutory construction, or about the rules, time limits that applied in the regulations, because that was an issue that affected large numbers of children. It wasn't fact sensitive, the ultimate issue of construction, and it had been fully argued, and it all went in favour of the court exercising its discretion to hear what was a claim that was academic for that individual child at the time. But the court, knowing that there were lots of other people affected, definitely weighed in favour of exercising its discretion.
Thanks, Ollie. And I guess the other question around there is the practical issues around people who already have busy lives with a lot of demands on their time coming together and continuing to pursue an academic claim. I'm going to do one more question that is related to tribunals, just because they're the ones that are coming up a lot. So somebody has asked, to aid equality of arms for Send tribunals, should access to legal aid for families of disabled children not be means tested? I think that's just worth answering.
So the way that an appeal is structured under Section 51 of the Children and Families Act for the Send Tribunal is the right of appeal is in the parent's name up to the age of 16. And so any HCPs go up to 24/25. I don't think we have argued or would argue that you get rid of means testing altogether for EHCP appeals. There is a real problem. The two key issues, well, personally, I'd love everyone to get legal aid, but particularly in relation to disabled children's social care and health and education. But a less radical proposal is actually making the means test fairer, because it still there are lots of people who families can afford a lawyer, who can't afford a lawyer, who are not eligible for legal aid. That's a huge gap. And then the other issue is actually how much the lawyers get paid to do this work. Because if legal help work, which is all of the preparation work for the tribunal, is loss-making, you're not going to get lawyers doing the work, apart from near enough as a quasi pro bono measure or corporate social responsibility exercise, which is not what the legal aid scheme is meant to be about. It's meant to be sustainable and actually work as a business for lawyers. But currently it's loss-making legal help work for Send Tribunal. So there isn't equality of arms. If you qualify for legal aid, very often you can't get a lawyer because the demand outstrips supply because of it's not viable work. And then you can't afford to pay for a private solicitor, but you're not eligible for legal aid because of the perversity in the means test. So there is no real equality of arms.
Brilliant. Thanks, Ollie. Well, Bethan, you wanted to add to that.
Yeah, well, no, I wanted to ask a question of Dame Christine, if that's possible. If I could ask you a question, Christine. Is that right? Okay, can I ask a question?
Yes, of course.
Is that all right? Yeah, thank you. So the slides I didn't get to were to do with advocacy and participation of children in decisions. And I wondered whether you'd had a chance to look at that part of the paper and whether you had any particular views about the proposal to do with independent advocacy being a right in some cases is the proposal. And also there's a discussion around when a child should be able to make some of its own decisions in relation to the assessment and service decision process. Obviously, local authorities make the decisions ultimately about what the service is going to be, but there are decisions about what to ask for and what to reject. Just to come clean on where we were on it, we were probably not as sort of, kind of open to it all as the Law Commission was, in that our position ended up being that we would follow the guide of the of what goes on in special educational needs, and we felt that 16 was a sort of cut-off point, and below that probably children should be protected from making unwise decisions. We wondered whether you had any thoughts on either of those areas, on decision making and on the advocacy rights that are in the proposals.
I think advocacy is always underdeveloped in this area. And I think partly that's because disabled children are seen as difficult because they sometimes have different forms of communication approaches. I think also we get very, very confused about the relationships between parents and children, and at one point they need to be separate and what point they need to be together. So I think there's quite a lot of stuff, and certainly when we also did Hesley, we were looking at non-instructed advocacy. So we were trying to work out what is real advocacy, because advocacy to me isn't somebody flying in who doesn't know the child, having a conversation and having it. It's a long process of supporting children to really think through what their needs are, and as you say, what the choices are. And we did government did a pilot with them under SENDIAS services a while ago, if you remember, looking at post-16s and whether you could go to tribunal and stuff. So the support and advocacy for disabled children per se, we should welcome. I agree with you about 16, that I do think any age restrictions on disabled children are always quite difficult, because it's not necessarily about age, it's about competence. And it's that balancing act, isn't it, really? But I do think advocacy for disabled children is horrifically underavailable, underfunded and understood. I don't think any of that made English sense, but you know what I mean in terms of what we're trying to do. So I'd be really, really keen, and I know we missed it today because Linda was not available, to understand where voices on this and what we think is real, because advocacy over the years I've worked in it sort of gets on the ground for a bit. We have a little project and then it dies a death again, then it gets on the ground and dies a death again. And it's something about how do you build advocacy into a system to support it to be sustainable.
Thank you, Christine. And I know Linda and I spoke when we were putting together Coram's response, and very broadly, I think she would agree with your point that it's understood, and she was concerned that the Law Commission didn't really seem to fully grasp what it was that an advocate did.
Yes,
and the actual role of an advocate. That is time, unfortunately. So I'm going to say no more questions. I just wanted to say thank you so much to all of our three wonderful panelists. We've had such a wealth of expertise here today. I'm incredibly grateful to all three of you for giving up your time to talk to us all. Thank you, everybody who has joined us.
Thank you.
Okay, thank you, everybody.
Very much.